All rise. The Court of Appeals First Appellate District of Ohio, with the Honorable Marilyn Cyrus presiding, is now set. Please be seated.
Good morning. I hope everyone's doing great. I'm still a little excited over the Bengals win on Sunday. Little carryover into Tuesday, I hope. All right, so we have a nice docket this morning. We have 5 cases that are on the docket. 4 are scheduled to argue this morning. I'm going to read out the entire docket. As you hear your case, if attorneys can please identify themselves and their readiness to proceed. All right? So the first case that we're going to argue today is Grant and Dana. I lost it already. Brazil versus Infrastructure and Development Engineering, Inc., case number C230172.
Jason Conti and Cal Green for Grant and Dana Brazil.
Scott Jones on behalf of Infrastructure and Development Engineering, or IDE.
Thank you. Second case for argument is State of Ohio versus Victor Lane, case number C230126.
Ron Springman on behalf of the state, we're ready to proceed.
Good morning, Your Honor. Carl Lewis on behalf of the Victor Lane, and we are prepared.
Then we have Thomas H. Camp versus Robert F. Gerwin II et al., cases number C230066-082.
Good morning, Your Honor. Alex Ryder on behalf of the colleagues of Robert Gerwin.
Good morning, Your Honor. James Patrick on behalf of the FLE, Thomas Camp, and we are ready to proceed.
The last case set for argument is Karen Lingo et al. Versus Anna L. Holmesy, MD et al., cases number C230135, 136, 137.
Alan Stackman on behalf of the appellate, ready to go.
James Englert on behalf of the appellees, Bethesda, Mercy, Dr. Malik.
And the last case, in this case, has submitted on the briefs is State of Ohio versus Eric Springs, case number C230143. All right, so we're going to begin with Roselville. I don't know why I'm having a hard time with such a simple name. Oh my goodness. Whenever you're ready, you can come forward. Would you like to reserve time?
Yes, please. 4 minutes.
4 minutes?
Yes.
All right. Whenever you're ready, you can start.
Good morning, Your Honors. My name is Jason Conti. I'm here on behalf of Grant and Dana Brazil. They are homeowners, essentially, who could lose their home as a result of the negligence of the appellee here, IDE. To give you a short timeline of what happened, IDE performed geotechnical engineering services on the property back in 2015. They essentially oversaw and certified fill material that was placed underneath the home. It was improper filled dirt. It contained organic materials. It wasn't properly compacted. And what's happening is the dirt is sliding out from underneath their house, and their house is essentially in danger of sliding down the hill. They purchased the home in 2017, so about 2 years after IDE did their geotechnical work. And then in March of 2021, the landslide occurred. And that's where the foundation was undermined. They had to do emergency stabilization piers to hold up the house temporarily, and it caused all sorts of real property damage to the house, the foundation, the utilities, all sorts of things like that. After the Brazils investigated the landslide with their own geotechnical engineering firm, and it was determined that the fill dirt caused the landslide, the Brazils filed suit. So a few months after the landslide occurred, the Brazils filed suit. The timeline here is undisputed, right? So I think the court is really presented with a choice here. The court can either follow the well-established precedent of Harris v. Liston, which says the discovery rule applies to real property damage, right? The statute of limitations is 4 years under 2305.09D, but the discovery rule established by the Supreme Court of Ohio says there's a 4-year discovery rule.
Well, counsel, isn't that for cases of ordinary negligence? Can you address the difference between ordinary negligence and professional negligence?
Sure. So yes. So there's a line of cases, obviously, which are related to professional negligence, right? So the Supreme Court has 2 other cases, Flagstar Bank and Investors REIT 1, right? Those cases involved economic losses caused by property appraisers and accountants. And there's a difference between real property damage, which can be hidden, like is the case here, right? So essentially, if you have an economic loss, it's more readily ascertainable, right? And so it makes sense that you wouldn't have necessarily discovery rule because within 4 years you can figure out you've suffered economic losses. Here, the landslide didn't even occur until 6 years after IDE did their work. There was no opportunity for the Brazils to discover or even know there was property damage that existed on their property.
Let's assume that we agree with you that that makes logical sense.
Yes.
What do we do with the language in Flagstar that is so broad that professional negligence claims are not subject to the discovery rule?
See, I think it's a narrow holding. I think that's dicta, and I think it's a narrow holding in Flagstar that just applies to that particular case. Now, other cases, right? There's a whole line of cases, as has been cited by IDE, which also relate to economic losses, and so, I mean, the court has a choice here, right? That you can extend those cases to real property damage claims like this one, right? Or you can hold back and say, no, we're not going to extend those cases to this sort of circumstance because it doesn't make logical sense here and it's not an equitable result. So just to give you an idea of what happens in a construction project, right?
It sounds to me in the onset of your argument, you weren't really asking for us to extend anything. It sounds like you were saying it just doesn't apply.
No, I'm saying IDE is asking you to extend the
Okay.
law of Flagstar and Investors REIT. I'm saying you've got clear precedent in Harris v. Liston saying real property damage has a 4-year statute of limitations with the discovery rule.
Is there a difference, though, between a developer/vendor and an engineer? I mean, what exactly does a developer/vendor do?
Well, so a developer develops property, right? So they control the project, right? The engineer, as in this case, depending on the specialty of the engineer, they do a structural engineering, they do geotechnical engineering, they do that sort of thing. And the difference here is that engineering typically at the beginning of a construction project is done at the beginning, right? The design work, just like happened here, right? Before the house was built, their work was done. Right? So it's done at the very beginning. And a lot of construction projects across the state of Ohio take longer than 4 years. Those big skyscrapers you see, big commercial buildings, right? They take longer than 4 years. So the owner sometimes doesn't even get occupancy before 4 years. If the court extends the 4-year statute and says there's no discovery rule, you could have owners across the state of Ohio who take occupancy of their buildings and they're already time barred from pursuing an engineer. In other words, you could have buildings falling down and the engineer comes in and says, well, I did my design work 5 years ago, it's time barred. You can't have that. It just doesn't make any sense. So whereas the owner typically will have a contract with the developer, right, because they're purchasing from the developer. A lot of times the owner doesn't have a contract, like here, with the engineer. So that owner is going to be completely barred from bringing a claim, and it makes the engineer and the architect litigation proof if you do that. So that's the issue, and that's why the court, at least in my view, you need to not extend the line of cases that are talking about economic losses for property appraisers, for accountants. And there have been cases that have extended it to engineers, but those cases involve economic losses as well. Again, things that are readily discoverable, The other thing to keep in mind here is there's a statute of repose. And the statute of repose establishes 10 years. And if you look at the language of the statute of repose, it specifically includes those that furnish design and oversight, right? So the legislature intended people to have 10 years to bring those claims. You're going to render the statute of repose meaningless if you have a hard cutoff at 4 years.
Well, counsel, I mean, aren't there other things that people doing design work can be sued for that the statute of repose would apply to?
What other things? I guess I would ask, because typically if you're doing design work, you're going to be sued for professional negligence. So architects and engineers are sued for professional negligence. Now, it's true if there's a contract, right, a direct contract between the plaintiff and the design engineer, right, then you've got privity of contract. But a lot of projects in Ohio, you have a separate developer who then passes off the project to the ultimate owner, and it's the ultimate owner that's suffering the damage, right? So you have in a project delivery sort of system in a construction context, you'll have a developer, right? He'll develop the project. He'll contract with the architect. He'll contract with the engineer. He'll contract with the general contractor. They'll put the project together, and then the developer will ultimately sell the project to the ultimate owner, right? And it's that owner that's going to suffer the damages, which is exactly what happened here, right? Now, this is a residential context, so there was no developer. It was a general contractor, but the general contractor contracted with the engineer, right, and then sold the house, right, to my clients. And so they're not in privity of contract with the engineering firm. That's why, right, the court has exceptions to the economic loss rule to give folks like my clients a claim against the engineer when you suffer real property damage, right? The idea is if you're suffering property damage and you could lose your house, you should have an opportunity to bring a claim against the engineers who committed the negligence that's going to cause your house to fall down the hill. So that's the idea. So it's just fundamentally different than when you've got an accountant, right, or an appraiser, or even an engineer where you've suffered just purely economic loss that you can see on your books. You file taxes every year. You understand you've suffered an economic loss, and you understand that quickly. Here, this is a hidden defect, right? So you move in, you think everything's fine, right? You file suit within a couple months of the landslide. And then the argument is, well, you're time barred. You had no opportunity. The argument essentially is you're time barred 2 years before the landslide even occurred. I mean, that just doesn't make sense. And like I said, from a broad perspective, you're going to have property owners all over the state of Ohio, potentially, who have suffered property damage, who are going to be time barred from suing their architects and engineers that caused the real property damage.
You have 30 seconds to wrap up.
Counsel, I have a question for you.
Sure.
How do you propose that we distinguish between the kinds of damage that you say should be readily available in a professional context, like accountants, in the other cases that you're citing, versus the kind of damage that might be hidden? Is it simply real estate? Is it something else? What is the dividing line?
Well, I would say it's real property. I would say it's real property damage, right? And what this court already, in the First District case of Chateau Homes, right, already said, look, we're not going to blindly extend the two cases, Investors REIT 1 and Flagstar Bank. We're not going to blindly extend that. If there's a principal reason why we should not extend it, we're not going to extend that law. And I've given you 3 reasons why, right, in this argument, right? The first being the nature of construction projects and the hidden nature, right? So the fact that construction projects and design work is done up front, and then 2, the hidden nature sometimes of property damage that doesn't happen until down the road, and then 3, the fact that the statutory scheme with the statute of repose is set up such that you should get 10 years to file your claim. So that's what I would say.
Thank you.
Thank you.
Good morning.
Good morning. May it please the court. Again, my name is Scott Jones. I represent IDE. The trial court properly granted summary judgment on behalf of my client IDE on the basis of the 4-year statute of limitations that applies to professional negligence claims in Ohio, specifically RC 2305.09D. There are 4 facts in this case, or 4 sets of facts that are undisputed and are dispositive here. First of all, professional negligence claims are in fact governed by 2305.09D. Second, IDE, my client, completed its investigation, completed its services on this project on September 3rd, 2015. Third, plaintiffs filed their lawsuit 6 years after my client completed their services on August 13th, 2021. Fourth, plaintiff clearly filed their lawsuit outside the 4-year statute of limitations. I'm very well aware that the issue before the court today is whether or not a discovery rule applies to professional negligence claims in Ohio. However, it is very clear, Ohio Supreme Court law going more than 30 years ago has established that professional negligence claims in Ohio do not have a discovery rule. As stated by the Ohio Supreme Court in the Wright versus Jacobs decision, they stated, and I quote, "The General Assembly has not adopted a discovery rule applicable to general negligence claims arising under RC 2305.09. The court will not interpret 2305.09 to include a discovery rule for professional negligence claims against accountants arising under RC 2305.09 absent legislative action on the matter." It's been well over 30 years since that decision. Despite the clear message from the Ohio Supreme Court, the Ohio legislature has taken no action whatsoever to amend 2305.09D to include a discovery rule for professional negligence claims. Moving forward.
That case involved accountants, is that correct?
That case involves accountants. However, it's very clear that is not limited to accountants based upon other Ohio Supreme Court cases, based upon courts that have interpreted that since then. That case has been expanded to surveyors. That case has been expanded to engineers. That case has been expanded to insurance brokers. It's not limited to accountants. Matter of fact, if you look at the Flagstar case that was issued in 2007, and that involved a case against an appraiser, they state, "We continue to adhere to the rule of law established in Investors' Right 1. A cause of action for professional negligence accrues when the act is committed. Just as accountants do, appraisers perform services that for 4 years may subject them to negligence suits for the consequences of their professional actions."
So one of the ways that your opponent has distinguished this situation is the latent nature of the issue.
Okay.
Which would not be present in your discussion of an accountant or what was the last thing you were talking about?
Appraisers, surveyors.
Appraisers, so like if it takes forever to figure out that your house is worth less than what the appraiser had ascertained it to be, I don't think that's an appraiser issue. So how would you address that argument?
I disagree because as I've discussed, this also applies to surveyors. Surveyors, if they perform a negligent survey, that would not be discovered until possibly years later when another survey is performed.
But wouldn't it be discoverable? I mean, those things are recorded. Pages has recorded those things. It's discoverable.
And so would this, Your Honor. They're alleging a negligence in a geotechnical evaluation. How did they ultimately determine that this geotechnical evaluation wasn't performed properly? They hired a surveying geotechnical firm to go out and do borings, and then that geotechnical firm discovered that there was issues with the soil compaction. So this is discoverable. It's discoverable just the same way that accountant negligence is discoverable, appraiser negligence is discoverable, surveyor negligence is discoverable. There are ways to discover this. So this is not latent. It can be discovered.
So if I'm understanding you, are you saying that even if we determine that the discovery rule applies, then your client would still win because it should have been discovered earlier?
Yeah, I mean, if that's what you want to the argument you want to go with, again, my position is that the 4-year statute of limitation commences to run based upon Ohio Supreme Court precedents at the time the wrongful act is committed.
Well, Liston was 10 years later.
But Flagstar was after Liston.
Okay, but I guess my point is, in Liston, I mean, it does say that negligence actions against a developer vendor, which I'll get to that in a second, is subject to the discovery rule. So a developer / vendor is a professional.
No, they're not. That's ordinary negligence. They're not licensed as professionals in the state of Ohio like engineers are. There's a clear distinction between professional negligence and ordinary negligence, which I believe this court has already discussed. These are professional negligence claims, not ordinary negligence claims. Okay?
Counsel, can we work through a hypothetical
Sure.
that kind of teases out these issues? So let's say that a building is designed by an architect, and it's indisputable that the architect has committed professional negligence in that design. The building takes 4 years to be constructed and built. And on 4 years and 1 day, the building is occupied, it falls over, and all of the occupants die. Is that claim time barred, and why?
That's a different scenario. As far as the claim, the people injured in that would have a lawsuit against the owner of the builder because they have a duty to those people. Then the owner has a contract against the architect and engineer for indemnification. And that's what we're really here to talk about, is there are means of recovery. Again, the plaintiffs bought the properties from the original owner of the property, the original developer of the property. They can sue them, which they have. And then that original owner, the original developer, can then bring a claim back against my client. So in your scenario, there is still a means of recovery by the injured victims, just as there's still a means of recovery for the individuals in this case. One of the things that I also want to bring up, and we talk about how these cases, there's this discussion, these Supreme Court decisions are limiting in nature. They're absolutely not. If you look at the Northern District of Ohio case that I cited, Lifetime Fitness versus Chagrin Valley Engineers, they applied that to engineers. Also, I want to discuss a 2018 Ohio Supreme Court case, LGR Realty versus Frank and London Insurance Agency. And in the concurring opinion by Judge DeWine in that case, I think that sheds a lot of light on how broad these Supreme Court cases are, and that these Supreme Court cases apply to all professional negligence claims. Judge DeWine stated, and I quote, "I agree with the majority's determination that the cause of action accrued at the time the insurance policy was issued. I write separately to make explicit what is implicit in the majority's decision today. A cause of action for professional malpractice under RC 2305.09D will always accrue at the time of the negligent act." After a lengthy discussion on Right 1, after a lengthy discussion on Flagstar, Judge DeWine then concluded his concurring opinion by stating, "A cause of action for professional negligence under RC 2305.09D accrues at the time of the wrongful act, period." Kuntz has been overruled. We should not be shy in saying so. So here is just another example from the Ohio Supreme Court that professional negligence claims, the statute of limitation is 4 years. It commences to run from the date of the wrongful act. Harris versus Liston, real property damage claims, ordinary negligence claims has no application to the statute of limitations for professionals in Ohio. I think one of the concerns with some courts in applying this 4-year statute of limitations sometimes suggests that this might result in harsh results. Well, I think the First District Court of Appeals.
One of the arguments of your opponent is it results in illogical results.
Okay. Well, it's a 4-year statute of limitations. Here, I would think it's equally illogical that my client could get sued down the road by someone whom they didn't even contract with. And so Harris versus Liston, I can even use that as an example. The plaintiffs in that case, the Ohio Supreme Court determined that the statute of limitations commenced to run many years before the plaintiffs in that case even purchased the property. And the reason why it commenced to run is because the original owners in Harris versus Liston had discovered the water issues. So even if you want to apply the Harris versus Liston logic, in that case, the Ohio Supreme Court said, well, I know you weren't even the original owners of the property, but since the original owners did have notice of this water issue, the statute started to run even before you purchased the property. So that issue, that concern, that's just a hurdle that exists. It always does. It may be perceived as unfair to some parties, but that's the law, that's the reality. There's got to be a cutoff. And I think the Ohio Supreme Court has developed a very clear cutoff here in saying that, listen, we can't parse out all these issues. At the end of the day, claims with regards to professional negligence commence to run from the date of the wrongful act. There are other ways for these injured plaintiffs to recover against the original owner by contract. There's other ways. We're just talking about one narrow claim sounding in tort. And going back to what I was discussing with the Hayter versus Grandison decision out of the First District, they addressed, some of this harshness, and they specifically stated, in looking at Right 1, they said, Right 1 may seem harsh and arguably out of step with the discovery rule adopted in other areas of tort law, but its holding is explicit and has not been subsequently modified or limited by the Ohio Supreme Court. And this is a decision out of the First District. Again, that is the case of Hayter versus Grandison, Division of McDonald and Company Securities, 101 Ohio Appellate 3rd, 99. So even the First District has recognized, it may seem harsh, but that's the law from the Supreme Court. That's the law as written. And at the end of the day, this is how the law must be applied. I know there's been some discussion about the application of the statute of repose. The statute of repose is not unique to design professionals. That's a very broad statute that applies to a variety of different developers, construction professionals, and that is a separate statute. That's a backstop, if you will, but that in no way is linked to or reference or limits in any way how 2305.09D should be applied.
Well, counsel, your opponent is arguing that the statute of repose, its mere existence, implies that the 4-year statute of limitations must be subject to some kind of tolling or some kind of extension. Otherwise, we wouldn't need a 10-year statute of repose.
Well, again, if you look at the situation of Harris versus Liston, when you have claims of ordinary negligence, I think the statute of repose is designed to address those cases where there's ordinary negligence involved against developers where there is maybe a discovery rule that applied. Again, the statute of repose is a very broad statute and is not unique to design professionals under 2305.
But it does mention design.
It does mention design, but again, I think with the statute of repose, their attention to do a catch-all of, okay, we realize that 2305.09D doesn't have a discovery rule for design professionals. We have interpreted other areas where there is a discovery rule applicable to other instances. So the statute of repose would mainly apply to those other instances. And that's what I believe the statute of repose is kind of a catch-all, like, okay, regardless of the claim, at the end of the day, there's 10 years to file a claim. And so unless there's any additional matters that the court wants to discuss with me, I think that's all my argument.
Thank you.
Thank you.
Counsel, your opponent's argument, I think, could be summarized to statutory interpretation. How would you respond to that?
Yeah, I think the statute of repose, if you're interpreting the two statutes together, and they should be read together, The statute of repose clearly says for those who furnish design and planning, right? That's clearly contemplated design professionals, right, which are engineers and architects. Opposing counsel argues there's got to be a cutoff. The statute of repose is the cutoff. That's the statutory scheme. The statute of repose is the cutoff, not only for developers, but also for design professionals. It's 10 years. Otherwise, what happens in those 6 years, right? I mean, if we're going to cut everything off at 4 years for architects and engineers, why say design in the statute of repose?
But it's not cutting everything off. The 4-year statute of limitations for negligence only cuts off the negligence claims. There could be breach of contract, there could be other things brought. The statute of repose covers everything, not just the negligence.
Fair, that's fair. But you've got to take into account the situation, right? The discovery rule, those sort of things, the context of what we're talking about here. And in the broader context, if you cut it off, right, at 4 years, especially in a situation like this, where my people will lose their house, if you guys decide that it's cut off at 4 years, they will lose their house. The developer is bankrupt. Their opportunity for recovery is against IDE, who certified and oversaw the fill, the improper compaction. And if we're in a situation where you've got buildings out there, again, this has broad application, whatever you guys decide here, this has broad application across the state of Ohio. This is the first time that you're going to be presented with a situation where the primary argument, right, is, are we going to extend Investors REIT 1 and Flagstar Bank to real property damage, right?
Counsel, why isn't this a legislative judgment that professional negligence claims have 4 years to materialize? And we're going to wait and see. If somebody commits an act of professional negligence, we're going to give the universe 4 years to see if that materializes. I mean, we have shorter statute of limitations periods in our law. Mm-hmm. Why can't the legislature make a determination that that's the amount of time that we're going to give for the world to order its affairs, to allow professionals to give some certainty to their business dealings?
Well, I would say the legislature hasn't made that judgment, right? The legislature has made the judgment, right? So the courts interpret the statutes, right? The legislature has made the judgment that there's a 4-year statute of limitations for real property damage. The Supreme Court has said there's a discovery rule applied to real property damage claims, which this is one of them, right? And then the legislature has said there's a backstop of the statute of repose. And the courts and the legislature work together. There's no statute that says you don't apply the discovery rule to real property damage claims for negligence. There is no statute that says that.
Is that not implied by the fact that 05D has some built-in discovery rule components to it that do not include professional negligence?
I don't think so. No, I don't think it is implied. I don't think the legislature has ever said, we're not going to give you a 4-year discovery rule for these real property damage claims, but not for these real property damage claims, right? And I think either there's a discovery rule for real property damage claims or there's not. I don't understand the distinction between ordinary negligence and professional negligence when it comes to real property damage claims. The Supreme Court has a narrow line of cases that says when you've suffered economic loss, right, you only have 4 years. And again, that's because that's readily ascertainable, and you should know within 4 years if you suffered an economic loss. Here, cases like this, and you gave the hypothetical of the building falling down, right? He's talking about a homeowner coming in and doing soil borings before they move into a house to see if the house is sitting on proper fill. I mean, come on. That's not realistic at all. No homeowner is going to go hire a geotechnical engineer before they purchase a house and go do soil borings to try to understand if there's issues that are 12 feet underneath the house. It's just not realistic. It's not going to happen. No property owner is gonna do that. So in your
I
hypothetical.
think I should have asked, instead of discoverable, reasonably discoverable.
Correct, reasonably discoverable,
Yeah.
that's right. And there's a reasonableness requirement to that. So, you know, there are property owners across the state of Ohio who will be exposed, right, if we're just gonna cut it off at 4 years. And they're just gonna have to eat any property damage loss that they will have. There will be homeowners, there will be commercial property owners, right? Because they're relying, and the developers and the contractors are relying on the design professionals to do appropriate work, right? And these construction projects sometimes take a long time, which, you know, I think your question implied. It does take a long time. So you could have property owners that move in and they're already time barred from bringing a claim against the responsible party. I mean, you've got to protect property owners across the state of Ohio here. You know, you can't allow architects and engineers to commit negligence in their design or their work, and buildings are falling down, one of which will be my client's home, right? And then them not have an opportunity to pursue the responsible party. And this whole idea that, well, you might pursue the developer or you might pursue the contractor. Well, here, the contractor's bankrupt. But you know what the defense is going to be in a situation where the contractor is not bankrupt? They're going to point at the engineer, the empty chair, and say, well, no, you need to apportion all the fault over there because it's their design or it's their issue. So it's not as simple as saying, well, there are other avenues of recovery, because there aren't other avenues of recovery. Even if the contractor who is bankrupt here was not bankrupt, if we brought the contractor in, you know what they'd say? IDE certified that we did an appropriate job putting the fill in. There's clear documentation. There's an engineer testifying, yes, I certified it. Yes, I said it was properly compacted, and then admitted he didn't follow his own compaction specs. The contractor's just going to say it's their fault. So there's not an opportunity for recovery.
Counsel, if you want to wrap up, unless there's any other questions.
Yeah, the only thing I'd like to say is, as I think this court already established in Chateau Homes, that they're not going to blindly extend Investors REIT 1 and Flagstar Bank. If there are compelling reasons not to extend it, this court's not going to extend it. And I think I've given you plenty of compelling reasons not to extend it under circumstances where you have real property damage. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a wonderful afternoon.
Appreciate it. Thank you very much.
I was sitting here thinking, good morning.
Good morning, Your Honor.
So we now have State of Ohio versus Victor Lane. How are you doing?
Good, Judge, thank you. Ron Springman on behalf of the state. May it please the court and Mr. Lewis. The state brought this appeal.
Would you like to reserve time, Attorney Springman?
I would reserve 2 minutes.
Okay.
This state submits it's a rather straightforward factual situation. We had two police officers that arrived on the scene. One had stopped Mr. Lane for outstanding traffic warrants, and during the stop, in plain view, noticed marijuana and a backpack protruding from a backpack. Mr. Lane was handcuffed and placed in the back of a police cruiser, and then the officers proceeded because they had probable cause to believe that there was evidence of contraband in Mr. Lane's car based upon the plain view doctrine and the discovery of the marijuana in the backpack. They proceeded to search Mr. Lane's vehicle, and pursuant to that plain view search, they did discover a digital scale, some cash, crack cocaine, and other evidence of criminal activity that formed the basis of these charges. You know, again, Gantt wouldn't be applicable in this situation because there was separate probable cause that the officers had to search the vehicle. It would be applicable if they didn't have separate probable cause to search the vehicle. Once you handcuff someone and place them in the back of a police vehicle under Gantt, then everything is secured. And unless you have separate probable cause to search the vehicle, police can't not search the vehicle under Gantt. But that's not what we have here. Actually, it's our position that Gantt would support the search here. And
So the discovery of the marijuana in the backpack is the game changer, in a way?
Yes, it is, and that allowed them to conduct a search of the automobile, and they uncovered, further evidence of loaded guns and so forth. So,
Was there any issue or any presentation with regard to plain view and the use of the flashlight?
well, I did cite a couple of cases where a flashlight was used just in case that, was an issue. As long as police use a device that's in common usage to enhance their view of contraband, they're always permitted to do that. And that's one reason why I think I cited, Jackson's on point, Wilson's on point, and I think it was Travick was a case that I cited where it said Officer Kramer's use of a flashlight was permissible and did not preclude application of the plain view doctrine. There's also another case.
But it seems like the trial judge's concern was not necessarily the use of the flashlight,
Right.
but basically searching for something rather than just happening upon it, which is kind of the prototypical plain view scenario.
Right, the officers arrived, it's my understanding of the facts, it's not disputed that there were capious and open warrants out for Mr. Lane's arrest, which formed the legal basis of the stop. And then once Mr. Lane was stopped, the officers were in a legal place. They were outside the vehicle when they observed the marijuana. And that is what provided the legal basis for them to conduct a further search of the vehicle.
Well, counsel, I think your opponent, I'm not going to put words in his mouth, but based on the briefing, I think he plans to argue that the Ohio Constitution embraces an inadvertence requirement, that the discovery of the marijuana in the car was somehow inadvertent, that the officer just happened upon it rather than intentionally went looking for it. And I think the argument is that on these facts, the officer intentionally returned to the vehicle with a flashlight for the purpose of trying to see if there was anything in plain view. Is that sufficient?
Legally, in all the cases that I cited in my brief and that I found, is the plain view doctrine. I not really think there is an inadvertence requirement. They were outside the vehicle. That was the key. I think the key fact here is the officers were outside the vehicle and they used the flashlight to determine what was in the vehicle, if anything. And it's perfectly legitimate under a whole plethora of cases, and I think I cited not to every one, but to the First District case, to the Jackson case from the Ohio Supreme Court. I included the one from Montgomery County because they used a flashlight. And I believe there's another one from this court that's cited in Wilson. It might be Ward, where a flashlight was used. And all those cases are pretty factually similar to this case. And I don't know.
What was he looking for? What was the purpose of going to look in the vehicle?
I don't know. I don't recall. I reread the record, so I don't recall.
Well, he had to be looking for contraband. There's
Well,
no other
that's-
reason he would be doing that with a flashlight.
Well, not just contraband, but maybe weapons or other things that might be in the car. That car, was probably most likely going to be impounded, and eventually it would have been subjected to an inventory search. Although I'm not saying that's implicated here, it would have been. I believe that would have fit that criteria, but that's not the legal theory we proceeded on, and I'm not suggesting.
Well, what about opposing counsel's argument that because marijuana is in some instances legal, in
Right.
the state of Ohio. And because hemp is legal, you see, the officer sees this baggage, maybe it's marijuana, maybe it's hemp, maybe it's legal, maybe it's not. So how do you address that?
Well, we got to keep in mind, Your Honor, you know, the United States Supreme Court, and I believe it's United States versus Place, said, well, that's a joint occupancy situation, but I did a sort of a deep dive into this because that was one of the state's concern when we did change the marijuana laws around and decriminalized it, made it a citable offense, and then we had the whole issue with the lab and hemp. And it seems like even in states that legalize marijuana, such as Colorado and other states, if law enforcement smells the odor of marijuana or they see visibly a leafy substance based on their training that they immediately recognize as marijuana, they're still under the law allowed to conduct a search. They still have probable cause to conduct a search.
But why? So let's assume the constitutional amendment passes and suddenly marijuana is legal in Ohio across the board. Like, what would their possible basis be under that scenario for probable cause to believe a crime was occurring?
The rationale is, in the cases that I uncovered in those states, if I recall correctly, was that if somebody has marijuana, it leads to the conclusion, again, police need probable cause, probabilities that evidence of a crime is present, that there could be other contraband in addition to the marijuana. But
Is marijuana still a controlled substance under federal statutes?
yes, it is. And I mean, I know there's efforts underway to change that. But it still does, I thought that, you know, the argument that Mr. Lewis made there potentially could change the law in these cases. It hasn't. Not even in cases where marijuana is legalized. I, to be honest, was a little bit surprised. I thought there might be some alteration in the law, but I guess the concern is marijuana can cause impairment. So it's just like alcohol. If you see alcohol in a vehicle, you know, you don't know how much.
Right, but if you saw it in, let's change the facts and let's say rather than marijuana protruding from the backpack, there was a 6-pack of beer.
Yeah.
Like, that wouldn't justify the search at that point, would it?
Well, if it was open container, it would, you know.
Right, but if it was just a closed, unopened 6-pack of beer, the officer wouldn't have probable cause to conduct a search.
Your Honor, I think you were right. I on that, it may have to be in a
premised,
bag.
isn't the whole automobile search that it allows for there to be a search for contraband in compartments where contraband could be? So I
Right.
think what this comes down to is whether marijuana would still be considered contraband.
And
if it is still considered contraband, then, you know, then that, we don't have an issue of probable cause, and we certainly don't have an issue of a search for contraband inclusive of compartments where contraband could be.
Right, right. It still is considered to be contraband. And even in the states where it's legal, it's still considered to be contraband. When I did my search, I have an old memo about it. It's a few years old, but that was one of the concerns because Ohio was considering medical marijuana, and you know the concern would be if officers arrive and have probable cause, can they base that probable cause based upon the presence of medical marijuana?
Yeah, because wouldn't otherwise then the default be that it's medical marijuana if it's not enough of probable cause?
I think
as opposed to the default being, you know, like, the default meaning that you begin at that point, and certainly the person can then establish that it is medical marijuana, right?
Right, that's what the law is saying, yes. And you can establish, you have your prescription and you can establish that it's for medical purposes. But, you know, you also get into this whole issue about, you know, driving impaired when it comes to marijuana and other substances that are found in a vehicle that also provides the probable cause for law enforcement to consider it as contraband and to be able to search the vehicle upon discovering it in plain view. And really, the Plainview Doctrine, we have the officer was in a legal place that the officer was allowed to be. They immediately recognized the substance in the backpack to be marijuana, and that provided them with a probable cause to search the vehicle, and in doing so, they found, a gun, digital scale, and other evidence of criminal activity that formed the basis of these charges. There really is no case law that would suggest anything differently than that this is a legal search. Maybe in the future, as we start developing case law with the difference between hemp and marijuana, there might be a different analysis.
Well, then maybe if marijuana becomes legal, then the default changes as well.
It might, and I would have said yes to that until I looked at some of the case law in Colorado and Oregon, and they still seem to allow a search if there's an odor of
Understood.
marijuana.
I have one.
Surprisingly.
I have one additional question.
Yeah.
The argument with regards to the use of medical marijuana and hemp no longer being a controlled substance in the state of Ohio, was that raised at the trial court level?
I don't think so. No, I don't recall that ever being raised.
So how should we dispose of that argument here?
I think here it would just be a straight application of the Plainview Doctrine under Wilson and Jackson, and that the officers, the basis of the search of the vehicle was they did discover marijuana in Plainview, and apply the case law that's been applied to these factual situations for a long time. I see this as unfortunately fairly clear cut with a recognition that it could change if the laws change, and I'm not sure even if the law changes to legalize marijuana based upon what I found in those other states. I'm not convinced that every state is going to all of a sudden make the determination that when law enforcement legally finds and has probable cause to believe there's marijuana in a car, that, well, they got to make a distinction whether it's hemp or not and determine what the amount of the active ingredient of THC is in. It seems like that might be a very complicated legal factual analysis, and it doesn't seem like the courts are going down that road in Oregon or Colorado. I know that's not relevant here, but for a broader discussion of what may happen in the future.
Understood.
So.
Unless there's any other questions from the panel.
Any questions? All right.
Thank you.
Good morning.
Good morning. How are you doing?
Pleasure to see the judges here, to be here. I apologize, I have a knee surgery coming up November 9th, so I'm limping a little bit.
Okay.
Good morning, Your Honor.
But your voice sounds great.
Sort of, Judge.
Okay.
Carl Lewis on behalf of Victor Lane, the appellee here. It's interesting that I find myself in the Court of Appeals for the first time in my entire career. And I find myself here because
I'm surprised to hear that, Attorney Lewis.
Yes, Your Honor. This has become, Your Honors, this issue with respect to the intrusion, and most importantly, the intrusion of individuals that every day are in our community, that you or I might not find myself in this same problem. As we put forth in our memorandum, the issue on behalf of the appellant, they missed it. The trial court got it right. As I did the motion to suppress, I reviewed the evidence and did the motion to suppress. The reality is we're now in a court of law citing cases, citing case precedent, but look at the facts. This gentleman had a warrant, parked his vehicle, surrendered to the authorities, law enforcement placed handcuffs on him, put him in a vehicle, the car was secured, despite the argument made by the appellant this morning was not going to be searched, towed, or inventoried. I wouldn't be here if that were the case. The car was secured. And as the trial court noted, and as Your Honor noted, what was the officer looking for but contraband? The purpose had concluded. The appellee, Mr. Lane, was about to be transported, or was being transported by another officer on the outstanding warrant. And
well, but I guess I don't understand your conceptualization of inadvertence, because I think part of the problem as I look at the case law and why courts have kind of shied away from embracing a robust doctrine of inadvertence is it's almost impossible to draw lines here. Like you can't say it's only plain view if the officer trips over it, right? Like the officer is always looking, whether he's in a house or at a car or something. And this time he happened to be aided by a flashlight, but let's just say he wasn't. Is the fact that he directed his head in the direction of the car or in the room where he's just made the arrest, like, is that inadvertence? Like, I don't understand where we draw the line. Can you help me out there?
That is a problem for us to address and try to resolve, but the inadvertence is not so much that, as the officer walked up to effectuate the arrest of Mr. Lane and said, whoa, what's that on the seat? That would be an inadvertence that I could not argue. But as the trial court noted, the purpose of the stop and the intrusion or the purpose that was there was concluded, was gone. Now, one might argue, Mr. Lewis, as your court's hinting, if another officer by chance saw the parked car and walked up and looked in and said, wow, what is that? That's an inadvertence. But what we have here is an officer who wasn't inadvertent but was basically searching. His purpose was to look and search even after the purpose of the stop and the arrest was done to see if there was something there more. Contrary, it wasn't an inadvertence, it was a search. And the court noted, what are you looking for? Why did you even go back to that vehicle when there was no purpose? I wouldn't be here, wouldn't argue if the officer or felt brother or sister officer was on the passenger side or assisting and say, well, I think I see something there. Then we have a problem. We don't have a problem. But this was not inadvertent. This was a search for all purposes.
But then are we
with
getting
the illumination of the light?
Are we then getting into like the officer's state of mind? Because I mean, clearly there's a lot of pretextual things going on here that we see on a daily basis.
Yes.
And the Supreme Courts, the courts above us have said, like, that's okay. Like, we're not going to get into a determination of was this pretext or was it not. So help me out as to, like, how would the inadvertence rule look from that perspective? Is it subjective or not?
I believe it is subjective. Most certainly subjective, but as has been alluded to, and it's like a threefold argument, and we raise those issues. The inadvertence, do you say, and I really appreciated the analogy that you stole from me, if it's a six-pack in the back of a backpack, then is that cured? Or in our day now with the hemp, marijuana, and the officer, of course, at the hearing says, I can recognize marijuana. I know what marijuana is. I'm experienced. But the inadvertence and the subjective thinking of the officer is, let me go back and see if there's anything more in the car. That is what causes the distinction here in terms of just a plain view, or the purpose here is I need to find something. And if in fact we get to that point, which I am aggressively pushing for now in my argument, is that we have a change in society. We're not there yet, Your Honor. You noted that marijuana is still illegal, and we're not sure where we're going to go here with it, but we're not talking about the Moore case where we have an odor of marijuana. That was not raised at the trial level. We didn't say he smelled marijuana. Was it burnt? Was it raw? No. I go back to the vehicle. I shine my flashlight, and that's what gave the court problems. Now I see something there that I believe, subjectively, to be marijuana. And the court, Your Honor, you hit it nail on. It's not. It's whether they have probable cause. Whether it turns out later that it's not, again, there's the intrusion issue. I'm probably not going to have that. If I had a green leafy substance in the back of my car, cop's going to say, Mr. Lewis, talk to you later. But if my client or anyone else has a green leafy substance that they believe that must be marijuana, there's intrusion right now, that's not a problem, but we believe that's not plain view. And again, this is not a complicated issue for me or for, I believe, the court. It's difficult in terms of the inadvertence, whether or not it was recognizable, and whether or not this officer subjectively went back to conduct a search.
It almost sounds like what you're saying, because this is not a pretextual situation.
Correct.
That's, okay. So it almost sounds, and you're not using this term, but the term that I keep hearing in your argument is fishing expedition.
Thank you.
That's what I keep hearing in your
agree.
argument, okay? So you're saying, hey, the purpose of the arrest pursuant to the warrant is concluded, and there should be nothing more, and anything more is in essence a fishing expedition.
I agree wholeheartedly, Your Honor.
That's what I'm hearing your argument as.
Absolutely, and I believe that's what the trial court was trying to get at when stating in the transcript, why would you go around and look in their car? The purpose was done. And I believe you hit it right on the point, Your Honor. And I really have nothing more. We've briefed it, we've written it, and I believe that the trial court got it right, and we would ask that decision stand, unless there's anything else. Thank you very much.
Please report.
I'm going to start asking you a question that, and if you can't answer it, I'm cool with it. This argument that once the purpose has been concluded, there should be nothing more, was that raised at the trial court level?
I just read the transcript, and I thought maybe the trial judge might have alluded to that. But I don't think it was raised other than that. And I just read it too, so
It's
I
okay.
apologize.
We've got the record, so.
I looked at it this way. I understand that, police officers, it's the nature of the work that they sometimes will engage in what we would describe as fishing expeditions. However,
Well, I mean, oftentimes the way the case works is like there's an arrest in somebody's home, and then they say, okay, we're going to do a protective sweep, and in doing the protective sweep, then there's something discovered under plain view.
Right.
So that, the whole pretextual thing comes into play.
Right.
We don't have that here. We don't have we went back to the vehicle to make sure there wasn't somebody there that we need to be concerned about, or something, it's just, we went back to the vehicle, we flashed.
Right,
Used the
and
flashlight, we looked in.
there could have been a number of reasons why they might have done that would coincide with good police work. But the key, I think, is whether or not what they did followed the law. And law enforcement in this situation, based upon paragraph 25 in the Ohio Supreme Court's decision in Jackson, based upon paragraph 11 of this court's decision in Wilson, police are allowed to stand outside a vehicle to see what's inside a vehicle. That is legal. You can call it a fishing expedition, but there's limits on that. They can't search that vehicle unless they find something, unless there's probable cause that would allow them to open the vehicle and
So
then
what you're
search it
saying under
further.
plain view is that law enforcement can just walk around and be looking at things that are in the public forum, and
Yes.
and if they happen to find something, they happen to find something. They don't need a purpose to do that.
Yes, there's 3 elements that involved the plain view doctrine. One, the officer has to have the legal right to be where they are. The incriminating nature of what is found is immediately apparent. And my age is blanking on the third one, but I don't think it's implicated here. But anyway, those 2 are what's important here, and the officer did not violate the plain view doctrine. All the elements were followed. The officer followed the court's guidance in Wilson, and in Wilson, paragraph 11, there's some other cases from this court dealing with similar factual situations, and that is once under the plain view doctrine, police discover contraband inside a car. In one case, I think it was a joint and an ashtray. That gives the officer then probable cause to search the entire vehicle. And we know that search is under Ross and Belton is a very exhaustive search.
Counsel,
That's the law.
let's send an officer on a true fishing expedition. Let's take like the Bengals tailgate parking lot during the game.
Yeah.
Everybody's in the game and we got a bunch of cars.
Yes.
And we're going to send an officer out to just start looking in them to find those open containers or the marijuana on the seat. Can the officers then just go in all those cars and start searching them?
Well, if the officer has a legal right to be where they are and they discover something in plain view, it's been the law since for forever that they then have probable cause to go in and search. I mean, that's just the law. I mean, I don't know how that would work public relations wise, but I mean, yes, that is the law. They, you know, as long as they meet the elements of the plain view doctrine, which I think were met here. And of course, the context here is a little bit different too, because they did stop somebody on some open felony warrants, and I'm sure there was some concern about what might be in that vehicle. You know, maybe some curiosity, but they were following the law. And that's what we're here to decide. Did the officers follow the law? They had a legal right to be outside Mr. Lane's vehicle here, and they had a legal right even to use the flashlight, and they found marijuana, and that gave them probable cause to search the vehicle, and that's the law we're relying on, and that is the law. So that's what we're just asking, is that, you know, this case get reversed and that that part of the law be followed.
Thank you.
All right. Thank you. Thanks.
Thank you both for your arguments this morning. We'll take the matter under submission, issue a time of decision. And Attorney Lewis, feel free to come back and visit us anytime.
Absolutely, Your Honor. Thank you. Thank you.
Camp v. Gerwin. Good morning. Good morning.
Good morning.
Attorney Roger, you can come forward when you're ready.
Thank you.
How are you doing this morning?
I'm well. How are you, Your Honor?
Good, good. I know it's been a long morning,
No, it's a pleasure to watch.
but it's your turn now.
All right, well,
All
I'll
right.
make the most of it.
All right. Would you like to reserve time?
I'll reserve 4 minutes, Your Honor.
4 minutes. All right. Whenever you're ready, you can start.
Thank you. Good morning, and may it please the court. Before I begin into the legal portion of our case, would the court like a recitation of the facts at all?
I think we're familiar with the facts.
I assumed as much. Thank you. I'll briefly touch on the jurisdictional issue that was raised. You know, I understand there's a distinction to be made with respect to whether there's a claim for fees or not a claim for fees. Obviously, from the appellant's side, once a final appealable order language is put into an order, we feel like we have to act, and so we filed a notice of appeal. We don't have a strong opinion one way or another whether or not jurisdiction is before this court at this point in time.
I mean, what's interesting about this case is that, you know, there's an award of attorney's fees, and while there's no calculus to it, it's a partial summary judgment. And so, you know, there are still other claims, although you're arguing that there aren't also. But
That's correct, Your Honor. And so from our perspective, we're not really focused on that issue. If it's remanded for determination on fees, we're just going to come back here and have this appellate argument again on the same issues that have already been raised.
What about
Yes.
the credit card claims? Can you address the jurisdictional implication of those?
And that's exactly where I was headed. I don't think the credit card claims are implicated. There's an order that's been submitted. That order is final with respect to that determination. Whether or not it's final appealable may be a different question. But that issue, if this is sent back down, that should not be reopened. That should be.
So you're saying the credit card fees have already been essentially litigated?
Yes.
Who won them? What happened?
Well, from my perspective, Your Honor, the way the credit card issue was resolved is that the court entered an order that was presented by the appellees in this instance that specifically resolved everything that the court asked the appellees to resolve, which is your motion for summary judgment is granted. Present me an order that you think sums up your arguments and the relief that you've been awarded. They did that. They submitted an order that summed up their arguments and the relief that they requested, and that order was signed, and that was submitted, and that's what the court ruled.
So they lost those claims?
I would say yes. I'd say the credit cards have not been awarded, and for whatever reason, but those have not been awarded. And
Well, it looks like, I mean, to me, it looks like they raised them but didn't actually develop them. And I think maybe there's an issue of waiver or forfeiture or something like that.
And that very well may be the case. It was a tangential reference
Right.
in one paragraph in their briefing. Obviously, it was also referenced in the prayer for relief and the complaint, but that doesn't necessarily get you to the point where you can say that you haven't waived.
But the claim was at least as I understand it, was still under the note and guarantee for the credit card fees.
That's correct, and the court ruled on the note and guarantee. And so from my perspective, that issue's been concluded until, we're before you. And so at the trial court level, we don't think that should be reopened. And the reason being, again, that order was submitted by them on their motion on the relief that was granted by the court, and they didn't specifically request that relief in their summary judgment briefing. Again, there's a tangential reference. It wasn't directed as a count. It wasn't directed specifically as their calculation of damages. And so the court was basically bound to enter the order that they submitted and give them the relief that they requested. With respect to our claims, starting with assignment of error number 1, it's our position that, first of all, below there are tons of issues of material fact that just...
So let me press you on that, because I understand that you say, hey, we've got an affidavit that says $95,000 less on the inventory. But what I've been trying to figure out, and have not been successful yet, so please help me, is what is that contractually based on? Like, are you saying we were supposed to get certain inventory and we didn't get it, and in this part of the contract it says I'm supposed to get this inventory? Or are you saying, and maybe it's both, we were supposed to get a certain amount of inventory value-wise and the valuation was off, and so there's a provision in the contract that says we're supposed to get this valuation and we didn't get it. So, like, where would I look in the stock purchase agreement to see, oh, okay, here's where the origins of the breach claim are?
Well, I'll be candid and say that the closing documents on this transaction were not pristine.
Well, that's why there's litigators, right?
Right, and so
clean up the messes.
There is a very distinct answer for your question, and that answer is this. There's a schedule attached to the stock purchase agreement. That schedule listed out what the inventory was that was to be acquired by the purchaser. When we went in, my client went in after purchasing, that inventory did not match up and the valuation was off by about $100,000. So there's a schedule that was attached to the stock purchase agreement. Unfortunately, that schedule was an email. It wasn't a buttoned up piece of transactional documents, but there was an email that was identified in the transaction as the schedule, and I don't have the exact schedule number in my memory right now, but there was a schedule that laid out the inventory. So that was incorporated into the stock purchase agreement, and so from our perspective, it was very clear that there was supposed to be a specific amount of inventory available to the purchaser, and it wasn't there.
Why didn't your client do something about that?
That's a great question, and the reason is that the appellee was employed by him when he took over the company, and the goal was to try to make a go of it. So, that may not be a legal defense to the question, but the practical reality is that Mr. Camp was an employee of the company after the company was acquired, and the last thing that my client wanted to do was be at odds with the person he had purchased the company from, who was supposed to be directing how he was going to run the company, help him make money, and so he chose to basically, for whatever reason, put his head down and try to work it out, as opposed to, immediately head to litigation.
And how was that not resolved by the 2020 inventory repurchase agreement?
Well, I'll address the inventory agreement and the First Amendment at the same time, if that's okay. The inventory agreement itself has a no waiver clause. So it specifically says that, yes, we're going to designate this inventory to be sent back to Mr. Camp personally for his own personal use. He can sell it. He can do whatever he wants with it. And as a result, we're going to do a reduction on the note of the valuation that's in the inventory agreement. But with respect to that, we're not waiving any claims. And so that's, in and of itself, I think, dispositive to their argument. But secondarily, the First Amendment also ratifies everything within the stock purchase agreement that was not changed by the.
But it also acknowledges, one of the documents acknowledges a default.
Yes.
And so your client is acknowledging that it's in default under these agreements. So how is that? I mean, the default has to be on not paying, and you're saying there was no obligation to pay because of this inventory, this threshold inventory issue. So how is that not at odds with your current position?
I think it's two-tiered analysis. I think the first part of the analysis is whether or not, and it really points to two questions. The first part of the analysis is whether or not the inventory issue is a waiver of the inventory claim, which I don't think it is, as I addressed Your Honor's question. And because it's not a waiver of the claim, that at a minimum, we should be entitled to the set-off argument that we suggested, because the set-off has been playing plain language of the stock purchase agreement. It says that if you breach the stock purchase agreement in any way, then we are entitled to set off anything we owe you underneath the note. That's in the plain language of the document. So at a minimum, we get that. It really goes to a fraud question, which we haven't really touched on yet. And the fraud question is the only way we can really say you can't enforce this document against us. And so if the defense of fraud is viable, then that second layer of questioning can be answered. But the first layer, I think, can't be set aside regardless. And I'll again be candid. I think the fraud argument's a little bit harder, but I don't think it's hard at all to believe that.
It looks a little time barred to me.
I understand the court's perspective. But I would say that the set-off argument is not barred at all. It's very much in the plain language of the agreement, and it was, frankly, the trial court's responsibility to determine whether or not there was a set-off that applied, and they jumped way beyond that, because the only way to determine whether or not the set-off applied...
Doesn't your set-off argument subsume the fraud claim, though? I mean, the set-off that you're arguing is that they owe you money because they committed, you allege, fraud. So isn't this all kind of circular?
It could be viewed that way. I would respectfully disagree, and here's the reason why. Because there's a distinction between breach and fraud. And so in this instance, the set-off argument is really a question of determining breach. So what our argument is, if you're going to say that we breached the contract, the only way for you to determine that we breached that contract is to look at all the contracts together and determine whether or not all rights and obligations were breached and considered. In this instance, we don't think all obligations and rights were considered, because in order to find a breach of the guarantee in the note, you have to first consider whether or not our set-off right subsumes that, to use your language. And so if our setup, for example, if we owed $10 under the note, but that we're owed $12 on the inventory, then we shouldn't be in breach pursuant to the set-off language, because there wouldn't be any damages. And so in this instance, again, I think they're just running in different paths. The fraud argument is completely different than whether or not there's a breach of any covenant or breach of the stock purchase agreement, or whether or not the set-off applies.
What exactly is it that you think that they owe you under the set-off?
Our perspective is what's owed under the set-off is, frankly, it's kind of crazy when I throw this number out there, but 50% of the value of the company. And here's the reason I say that. In purchasing this company, my client did not make a cash payment and say, here's what you get at closing. Instead, it was, we're going to promise to pay on this note, on this debt that Mr. Camp made to the company himself. That was the representative value that he was obtaining from selling the company. But he made a representation.
We agreed to absorb all the obligations under the obligation.
To absorb all his note, the note that Mr. Camp made to Camp Safety. That was the debt obligation that my client was absorbing. He was going to make payments towards that debt obligation in order to repay Mr. Camp. But part and parcel of that was the assumption that he was going to have the value in the company to make those payments. For example, another $100,000 in inventory. That inventory is already paid for. It's been cashed out. That's basically like $100,000 in cash in the bank that can be sold. And so when we go in to then make payments on the agreement, we find we have $100,000 cash less in the bank. That's a big deal. And we sold the company, or we agreed to pay.
But you guys did due diligence here, and the due diligence, I'm not a corporate lawyer, but I had friends that did this, and it was to figure out exactly these kind of issues so you don't end up in this scenario.
I wasn't involved in the due diligence portion. There was a due diligence aspect of this. The due diligence.
But it would involve looking at the records to determine, are these records legit? Are people cooking the books? Those are the kind of issues that people look for in due diligence.
And what I can tell you is that there was due diligence performed. The QuickBooks were provided to my client. You can see in the briefing that there's a couple areas of the QuickBooks that we found to be concerning. If the court wanted to dive into it and read the deposition testimony, which would be quite tedious, but the deposition testimony goes into the fact that Mr. Camp couldn't explain what the issue was with the QuickBooks. There was two things in there that he didn't really understand how to reconcile them, so he himself didn't understand them. And again, it's not a big company, so the risk maybe up front, it reduces the due diligence timeline. And frankly, it took about 6 to 7 weeks after my client took possession of the company to perform the inventory analysis. And so the timing may have been, frankly, the consideration as to why the due diligence could be completed on that aspect of it. So again.
You have 30 seconds to wrap up unless there's any other questions.
Thank you, Your Honor. So I'll just note that, again, I think that the set-off analysis, I think our breach claims, I think our defense to their breach claims, I think Mr. Camp's performance as an element of whether or not he's entitled to breach, all of those things are riddled with questions of fact. We presented affidavits showing that the record keeping was bad. We presented QuickBooks records that the court presumably struck. We can't really tell because the order was so broad. But presumably the court didn't consider the QuickBooks records that were submitted that showed the indiscrepancies that we alleged existed. All of those issues are questions of fact that the court should not have determined. At a minimum, the court could have found a breach with a hearing on damage. We didn't even do that. And at the end of the day, all those questions of fact were premature. The court weighed the evidence, and they shouldn't have done that. And so for those reasons, we believe that a vast majority of these claims were premature and should not have been granted summary judgment on. And I'll reserve my 4 minutes unless there's any additional questions.
Thank you.
Thank you.
May it please the court, Mr. Roger. The court, in granting summary judgment, both on the affirmative claims of the appellees and on the defensive claims, is nothing different than what the appellants did through the ratification by words and conduct. So let's look at what the court did. And you've touched on it, Your Honors, very poignantly. The court says there's a promissory note and a guarantee. We grant you judgment on those. The guarantee includes the credit cards. There's no dispute. The credit cards have been paid for in the relief. They grant judgment because there is nothing to defend on the note, which is an unconditional promise to pay by definition, and a guarantee, which is also an unconditional guarantee. So, on the affirmative claims, the court grants judgment, but misses the fact that those credit cards...
Well, but I don't think you can blame the court for that because you all missed them. You didn't have them in... I read your partial summary judgment motion, and I see the credit card claims mentioned, but not developed. Like, this is your claim. You're saying this is undisputed facts. We win, and you don't put that in front of the court.
Well, it is in front of the court, Your Honor. When you file a motion for summary judgment, the allegations of a complaint also count under Rule 56. So what happens
no, you have to put admissible evidence in to support them.
Well, it can be a combination of discovery responses, pleadings in the case. They never opposed that. There's no dispute. That's the irony of this, is they want to say that we don't owe the credit card bills, but they never did anything in opposition to say.
But that gets back to my point. You didn't have a separate heading in your summary judgment motion that says, we get the credit card fees, and here's why, here's the basis, and here's the amount. If you had done that, then they would have had the obligation to respond, but you didn't do that.
Well, no, we did, Your Honor. If you count two as the guarantee.
But where in your summary judgment briefing do you make this argument?
The argument is made through the guarantee because the guarantee specifically
No. I'm sorry to press you on this, but I want to understand.
Sure.
Where in your summary judgment briefing is this argument made?
Again, we allude to it. I know the court is looking for something developed, but it's an undisputed issue that was brought up because the guarantee and its express language, which is an exhibit, the guarantee is part of the record. The court can look at the record and see that the obligations that were picked up, contrary to what Mr. Rogers says, the debt of the note was picked up and the credit card debt were picked up. And those are affirmatively brought up in a motion for partial summary judgment. What happens in response? Is there an opposition to even the guarantee period? There isn't. We go down the road on set-off, and I'm going to address that shortly because it's a red herring, but it's an unopposed motion effectively because you've got a note and a guarantee that they've never disputed. What they're saying is we've got something out here in the form of fraud, in the form of misrepresentation. That's the defense. They've never opposed the idea of the credit cards. And to your point, Your Honor, that's where they're conflating. Because what they're saying is everything absolutely flows from the concept of fraud and misrepresentation. That's the whole game. Inventory is off. Payables are somehow off. And the only way they can get there is through a set-off argument. The problem is, set-off is not an element of my damages claim. On a contract claim, I show breach, I show a contract, I show a breach, and I show damages. And we did that. It's not part of how Mr. Rogers suggests we fix it within the analysis of my damages. If there's a dispute as to damages, that's different than a set-off. Set-off is not a disputed damages issue. It's an affirmative defense. Columbia Green, the case, it's an affirmative defense that must be proven by the party advancing it. That's the set-off. They have to affirmatively show that. It's an independent...
Let me press you on that. So they say, well, we did that. We showed that we got an affidavit by this guy that says I was supposed to have $95,000 more in inventory, and you say that's wrong, but they say, well, that creates a genuine issue of material fact. So what's wrong with that?
Well, it doesn't because, well, there's twofold. One is the court rejected it, and
that's what we're here to figure out, whether that was correct or not.
Well, but it's a different standard. We look at summary judgment de novo.
Right.
On affirmative defense of a set-off, the standard is abuse of discretion. The Fickus case that we cited in our brief says, allowance of a set-off is a matter within the sound discretion of the court, and the court's decision will not be set aside absent a clear abuse of discretion. And the court did not abuse its discretion.
I tend to disagree with you on the standard of review, because we are here on summary judgment, and the issue is there a genuine issue of material fact on the claims that they are bringing forward? So let's just leave that aside, whether it's de novo or abuse of discretion.
Fair, Your Honor.
Tell me why there's not a disputed fact over the discrepancy between their affidavit and what you're claiming.
Well, it was more fundamental than that. It's time-barred, Your Honor. Set-off, remember, flows from this concept of fraud and misrepresentation. We've got representations that have a 5-year maximum limit. They're not valid. They do not survive after 5 years. That's even undisputed.
But they're not basing their claim on a representation that's being made today outside of the window represented in the contract. They're saying you made the representation, or the client did, so many years ago, and we were damaged and continue to be damaged now. And that's within the statute of limitations.
Well, no, it's because it's contractual in nature. What it says is, as of the date of closing, we make these representations to you, but we only stand by them for 5 years.
You're pointing to the language that's in the contract.
Absolutely.
Yeah.
And that's what the parties agreed to. They said, I mean, we didn't just sign it. They signed it too and said, those are only good for 5 years. And you have to do something.
There is a case out there that specifically addresses that and talks about how, and it's language that's very similar to that within your contract. And because it doesn't go on to take it a step further and limit the time to bring forward the lawsuit, it wasn't treated as a bar similar to a statute of limitations.
Well, and I'm happy to look at the case, Your Honor. I'm not familiar with the one you're citing. I can only say that there can only be one reason for that provision. What else does the 5 years mean? It only means that they're valid for 5 years. That's
Counsel,
the express.
I just want to refine my question a little bit, just so that I can make sure I understand your perspective. I don't understand them to be arguing that they are harmed by a 6th-year representation. I think they're saying they're harmed by a first-year representation that would fall still within that contractual time period. How do we look at that from a statute of limitations perspective?
Right. So a contract is signed, and then it says certain provisions survive. They continue to be valid for 5 years. That means you have to assert your claims on the reps and warranties within the 5-year period. That's why they survive for that long. Year 6, they no longer survive.
All right.
And that's precisely what happened.
You're saying that the contract language changes the statute of limitations.
It's one aspect, Your Honor, because that's the contractual piece. Fraud, as you've pointed out, Your Honor, it's undisputed that this gentleman, who has an accounting background, by the way, had a lawyer and an accountant involved in due diligence, prior to closing. And then 2 weeks after closing, his testimony says, oh, I've got an issue with the inventory. He makes payments for the entire year of 2016. He makes payments for the entire year of 2017. Comes around in 2018 and says, I want a loan modification. I need to restructure the terms. And what does he say in 2018? He says the outstanding principal is $361,000 plus. That's what he says. And he ratifies the note and the guarantee. That's in 2018. Then in 2020, they say, we're in default. It's an undisputed fact, Your Honors. With all due respect, there isn't much you can say about the fact that they said. And the cases are very clear about ratification because it addresses this concept of fraud. And I'm going to quote it if you would allow me, because it is absolutely directly on point here. An intelligent and intentional ratification by the injured party of a contract voidable on account of fraud will, as a general rule, preclude the party from afterward insisting upon the fraud as a cause of action. And that's the Monoyulis case that cites Deans versus Yates, which is a Supreme Court case. What that's saying is, after the fact, you've ratified it. Imagine in your own personal lives, you buy a house, you sign the mortgage, and then 2 years later you say, I want a loan modification because I want to lower my payments. And you agree, I owe the money, but I just want to restructure that. And then you go back again to the bank and say, you know what, I want to strike another deal, I want to make some kind of advance payment on it or whatever. 6 years after the fact, but now you're going to go back to year one and say, oh, you duped me into giving that loan? That's what you're in effect saying. And that's exactly what this is. This is seller financing. He took a note back. It's his entire investment, frankly, in this business.
The waiver claim that's in the 2020 inventory agreement is not in the 2018 first amended note, is it?
Yeah, so the way it's a waiver
provision.
provision, it applies to both parties. It's also saying, Mr. Camp, you aren't waiving your rights to go sue on your note. That's all it's saying. But it doesn't negate the fact that their default. They affirmatively said, we are in default. We owe the money. Common sense would say, if you had an inventory issue 6 years ago, would you not say it? In 2018, would you not say that, oh, I owe $361,000 plus less any set-off concept I might have? That would make sense, but it didn't exist. And then you go back in 2020 and you say the same thing. I'm in default, and I have an accelerated balance. I owe it, and that includes the credit cards. And now they want to come back and say, well, wait, no, we have this concept of set-off years afterwards, and after they've already ratified through their conduct and their words absolutely everything that took place up to that point. And that's and so we believe, Your Honors, that the court got it right with the exception of not fully accounting for what the guarantee prayer for relief was. The court did grant. It's in the order. And by the way, we did not generate that order. I don't know where that came. That was a court-generated entry decision. It says, I'm giving you judgment on counts 1 and 2. Note and guarantee includes note plus credit card debts. They both do. So it would be absolutely unfathomable to not include the debts that we know are inside the guarantee and that are never really disputed.
But I mean, that gets back to where I started, which is in your summary judgment motion, you didn't ask for that. You asked for the concluding paragraphs, whatever the amount was the amount that the court put in its ultimate entry. So I feel like if you had asked for the credit card debt, maybe the court would have given it to you.
Well, Your Honor, then, I mean, I believe it's there. I know it's not fully developed. I would acknowledge that. But if we're looking at it de novo, And we're all sitting here and saying, the judge clearly granted count 1 and it clearly granted count 2, but somehow count 2 got parsed out somewhere down the line? No, they never made that argument. The appellants never said, we do not owe these credit cards. It's nowhere in the record. Yet now they're creating this idea like, oh, well, we're off the hook. No, you're not, because the court did consider the merits of counts 1 and 2 and granted them. It's just missed the fact that these credit cards do exist. And and if we're looking at it de novo and we're going to do the right thing, in our view, the right thing is let's give effect to what the court found and give effect to what's undisputed. Because again, it's not in dispute. It is now, but it was never in dispute in that court record. Mr. Gerwin testified. His deposition's on record. I mean, he acknowledges those credit card debts.
Isn't the issue of the obligations, what the obligations are, isn't that an issue of fact?
I don't believe so. I may be missing your question, Your Honor. I'm going to answer it this way.
Because you're saying de novo goes to issues of law, but it doesn't go to the issues of fact. And it seems to me that you're asking us to apply de novo to an issue of fact.
I don't think so, Your Honor. Legal construction of contracts is a contract interpretation is a matter of law. And so what the obligations that are within those, including the guarantee and the money that's due under the guarantee, can be decided by the court as a matter of law.
Right.
That's all we're saying. We think mechanically on the issue of final appealable, we believe it's a mechanical issue that you can just calculate. You can go back and say, okay, we know what the credit cards were on the date of the complaint. We know what the interest is. We know, and it's mechanical. It won't. I think the litmus test is always, is it going to come back to this Court of Appeals a second time to relitigate? And I think the answer is probably not. I understand both sides of that argument in terms of final appealable, but in our view, this is a pretty mechanical calculation. And again, it's not derived from an issue of fact. They're not saying, no, we only owe $20,000, or we only owe $15,000 and the interest is wrong or something. They never said that.
And while that's fair, it seems like you're asking us to read into your prayer of relief beyond what it actually says.
Your Honor, with all due, I think our prayer for relief is pretty specific. It talks about Bank of America.
I'm not talking about the complaint. I'm talking about the motion.
Oh, Your Honor, yes. I would say we believe it's there. We believe it's undisputed. It was never contested by the other side on that basis. So we don't think it's even a disputed issue. That's why it can be ruled on as a matter of law. But to the extent, yes, if that needs to be part of the judgment, to effectuate the judgment of what the trial court did with counts 1 and 2, yes. That would include those credit cards. Did I answer your question?
I understand, yeah.
Okay. Unless there are any other questions of me? Thank you, Your Honor.
Thank you.
And I didn't really address it to the extent there's going to be any rebuttal to my cross appeal. Is that of concern to the court, or?
Oh, you know what? That's right. I didn't ask you if you wanted to reserve time.
I know I used a lot of time, Your Honor. If I can reserve 1 minute, it should be sufficient.
I'm sure that's fine.
Mr. Paprick talked about common sense. Common sense is great. I want to use it every day. But that's not what this court should use. This court should use the law. Common sense is for the trier of fact. The trier of fact here got it wrong because they weighed evidence that they shouldn't have weighed. Material questions of genuine fact were presented to the trial court, and they went ahead and made those determinations.
What about this 2018 First Amended Note and the idea that if there was some kind of fraud that occurred, that it should have been brought up at that time before the note was renegotiated?
Frankly, I'm at a loss to what portion of the amendment says that fraud should have been brought up at that time. The amendment specifically addresses a couple of different things, but it doesn't address whether or not the parties have any defenses or claims against one another. It ratifies a couple of things within the note, but it doesn't specifically say, oh, and in addition to that, I'm waiving all my other claims I may have against you. It's simply an amendment to an existing document. And so while there may be admissions with respect to payment or anything along those lines, it's not a waiver of anything else. And I think you have to be limited to what it specifically says. And what it specifically
In
says.
essence, what you're saying is the amendment didn't replace the stock purchasing agreement.
Not in the least. It supplemented it. And I think it's very clear that that's what it says. And it specifically says within the amendment that that's what it's doing. It says that all other portions of the stock purchase agreement are unchanged. And that's what the amendment lays out. So, unless it's specifically addressed, it remains unchanged. And frankly, with respect to the ratification argument, the case that Appley relies on, the Montejudos case, is distinguishable here, and so are the other cases that they cite to with respect to that. And the reason being is that the ratifications in those cases were quite clear. And in our case, we have two instances in which they're alleging ratification. You have the First Amendment, which I just addressed. It's silent on most of these things, which means that you go back to the stock purchase agreement. And secondarily, you have the inventory agreement, which specifically has a no waiver clause and preserves those claims. So you're not ratifying anything when you're specifically preserving something.
But again, I'm looking at the language, and it says loan documents are in default, and the entire unpaid principal balance and accrued interest have been accelerated.
And again, my take on it is we're looking at
because your position is that's not true because of the set-off, right?
I think there's a difference between default and litigating of the full scope of breach, right? So you have, in order to litigate the full scope of breach, you have to make a damages determination. To make a damages determination, you have to weigh the facts that are presented before the court and make a determination of who owes what and why. And in this instance, the evidence that was with respect to the inventory and the accounts payable was completely neglected and not considered, or if it was considered, it was weighed by the trial court and disregarded, which is not permitted to do.
But the language that Judge Bergeron just read to you says the whole note is in default and it's being accelerated. The whole balance is due. So why then does a fraud claim and a set-off provision survive?
I'm not arguing the fraud claim survives based on that. The fraud claim, in fact, I haven't even argued to this court one time in my briefing or today that the fraud claim is alive. The fraud defense may be alive, but the fraud claim is not alive. I'm not suggesting that the fraud claim is alive. I agree that the fraud claim is gone.
Well, how does a defense survive then?
Well, defenses are not barred by statute of limitations. The statute of limitations is explicit and it says that claims must be brought within a 4-year period. It doesn't say that defenses cannot be raised after that 4-year period.
Maybe you're not understanding my question. The note is a contract between the two parties, and the two parties in a note agreed that the entire balance was due.
So are you suggesting then that at that point in time the claim to any set-off has been waived potentially at that point?
I mean, that's what the parties just agreed to,
Okay.
potentially.
Yeah.
Tell me why not.
So respectfully, I disagree, and here's the reason why. Again, I think the document in and of itself, while you're conceding default and saying, here's the balance, it doesn't specifically say, here's the balance owed, and I don't get my set-off. The set-off language actually plays right into this. The set-off language says that Gerwin may set off any amount owed to it by the camps pursuant to the provisions of this agreement against any amount owed by Gerwin or the company under this agreement, including without limitation, the obligation under the note or any agreement or document contemplated.
Well, let me ask you something else. So your client transfers the entire inventory to Mr. Camp under this inventory agreement.
Not the entire inventory, a portion of it.
I thought it said everything.
No, he continued to operate the business after the inventory agreement. So not the entire inventory. There was actually a specific category of
Substantially all of the inventory wherever located, whether used, new, old, blah, blah, blah.
My recollection, I could be wrong, but my recollection is that there was a specific category of inventory that was transferred to Mr. Camp that he was permitted to sell, and that carves out, in fact, the inventory carves out that this is not a violation of any non-compete or anything like that because there's still an operating business going on. That's my recollection, but I don't have it in front of me.
Well, I guess my question is, if this definition is broad enough to be all the inventory, and what you're saying is we should have gotten more inventory at some earlier point in time, aren't you just transferring whatever that is back to them?
Well, assuming that's correct, which again, I'm not certain that it is factually.
Okay, I may be wrong.
Assuming that's correct, I still think that just simply because you're transferring back what was owed doesn't mean you got value for what you paid. And it doesn't mean that you're waiving the claims, because again, there's no waiver clause in there. Mr. Paperkirk noted that there's a no waiver clause in there to protect Mr. Camp, but I would say just conversely, there's a no waiver clause in there to protect Mr. Gerwin equally. And neither side should be prohibited from bringing claims in the future when there's a no waiver clause on a document they signed. That would be my position on that. With respect to things being time barred, I think when you're looking at time barring a claim, you have to be very explicit. Your Honor noted that there's a case that says that unless it's explicit, it's not barred. But even to distill it down more distinctly here, I don't think it should be time barred here unless that particular claim is called out, much less whether or not it says it has to be filed by a certain date. And in this instance, lots of claims are not called out. Defenses aren't called out. Defenses aren't waived. And so while the reps and warranties may be at a 5-year point, and I defer to Your Honor on that precedent that you cited to, it doesn't say that all other covenants are waived. It doesn't say the covenant of good faith and fair dealing is waived. It doesn't say that the right to set off is waived. It doesn't say any of that. It just says that these particular issues should be raised within a 5-year period, and that's all it says. So I don't think that our defenses are certainly not time barred, and I don't think our claims for breach are time barred in totality. And I will note that just because factually some of these claims relate to fraud, Mr. Paperkirk has made that point. We're just talking about fraud. We're just talking about fraud. We're just talking about fraud. Well, he wants us to think about fraud because our fraud claim stinks. I get it. But there's a lot of other claims out there. And just because the facts relate to fraud doesn't mean they don't also relate to breach of contract. They can relate to both. And so, yeah, our fraud claim stinks. That's why we didn't bring it. But the breach of contract claim doesn't. And I know I'm running short on time, so the last thing I'd like to note is that the back 2/3 of their final brief is a second opposition to our briefing. And that should not be considered. In fact, some of the cases referenced today at oral argument were only included in the back 2/3 of that brief.
I noticed that, counsel, and I agree with you.
Thank you. And so we just ask that law not be considered. And I'll also note it's not dissimilar to the credit card issue, in which if it had been briefed, certainly we would have responded on the credit card issue at the lower court. We didn't respond because it wasn't briefed. So unless there's any further questions, I can consider my time concluded. All right. Thank you very much.
I'll keep it brief. I don't know if I misheard Mr. Roger. Number one, he said his fraud claims stink. I did catch that, which is an affirmative claim that got dismissed. But also, I thought he said that he raised an affirmative defense of fraud, and that is not the case. That was one of the central issues in this. So I just wanted to remind the court, and under 8C, that's one of those specific defenses. You either assert it or you waive it. And so the idea that now these fraud elements come in here. The contract, Your Honors, again, fraud is a tort, contract is a contract, but either path you take is time barred. And so the idea that the affirmative defense has no time limitations has no weight in this case because they didn't assert that affirmative defense. I don't know which cases Mr. Rogers is referring to. I apologize to the court if we extended beyond the scope, but the Monoyides case is, I think, the only one I cited today in Ficus. I think we already cited that in our primary brief. I may be wrong, but that's what my notes seem to indicate. And those obviously, I don't think the court turns a blind eye towards case law that exists out there when it's aware of it. And to the extent we did that, I apologize, but we do want to make sure that the legal merits of this whole matter are considered. Kind of one of the ironic comments, and I'll leave it at this, is he said, well, the inventory, to your point, Your Honor, is like, well, the inventory got sold all back. Isn't that all kind of part of the mix? The answer is yes. It's substantially all. It is that. I don't know, maybe his memory doesn't, but the language of the agreement specifically says that. But then he made a comment about, and the value was paid for that inventory. No, it was not. That's the way we're here. They never paid value for anything. They own the entirety of this note and the credit cards. So the notion that somehow there's just this injustice that somehow occurred, and again, that's not the guiding principle in today's appeal, but the notion that somehow they didn't get all this inventory, but they turn back around, sell it, make all these deals, and then on top of that, they're saying, oh, but our value paid is gone? No, they're not. We're the ones trying to collect the money. And I just want to make that point because, again, I do think common sense doesn't go out the window, and certainly we would ask this court to adopt the trial court's decision with the exception of either remanding it back to the court to make that final, because there is a lingering issue about attorney's fees that we need to litigate down there. Remanding it for the purpose of getting the credit cards entered as part of the judgment would be our request. Thank you.
And you weren't asked, what's your position on finality?
Your Honor, we believe it's mechanical enough in calculation that it could be a final appealable order, but I think I said it earlier, I can see both sides of that because, you know, we do have an attorney's fees issue that's being litigated. I don't think that affects the finality per se, but I've also seen decisions out of this court that say it does. And I don't want to, you know, I want to be open about that, and I can see it kind of both ways. Our view is that the credit cards are so finite in what they call for that it wouldn't affect the finality, but again, I defer to the court on that.
Thank you.
Thank you.
Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. We wish you a wonderful afternoon.
Thank you. Take care.
Lingo v. Holmesy. You can come forward. Good morning.
Good morning.
We're still in mourning. Come on forward. How are you doing today?
I'm doing just fine. I entered an appearance this morning, and so here I am.
Okay.
In assistance to Bob Winter. Good morning to all of you.
Would you like to reserve time?
4 minutes.
Okay.
I don't think I'll use all 11 minutes now. I think that the issue's clear, times 3, and I think the answer is simply that the sanctions motion is premature. Rule 10 says that if you file a complaint without an AOM, it's a failure otherwise than on the merits. So whether one files a motion to dismiss or the court makes that ruling sua sponte, the case ends up dismissed, just like a 41A dismissal. And so whether you're looking at Rule 10 or you're looking at Rule 41, that failure is otherwise than on the merits.
Counsel, I want to cut straight to the chase here. It seems very clear to me that if there was a failure on counsel's part, that it was solely limited to not asking for the extension that is allowed under Rule 10. Is there any reason why the attorney would not seek that extension?
Well, the record's devoid of what Mr. Fagan's intent was one way or another.
In cases like this, can you help me understand
well,
why?
If we're just going to talk about what would I do in a similar circumstance, it's really fact dependent on why I don't have the affidavit of merit at that moment. I might file it knowing that it's going to be a failure otherwise than on the merits, and that would give a year from that point of view to fix the problem of finalizing an affidavit of merit with the appropriate expert.
But the problem is that that's not what the rules provide. The rules provide a very specific path forward if you don't have the affidavit, and that is this time extension that is contained in Rule 10.
But the rule does contemplate that if you don't follow the rule, it's dismissed otherwise than on the merits.
That doesn't mean it's not sanctionable at that point.
Well, no, it means it's refileable. And I think Judge Branch got it correct which is if it gets refiled without an affidavit of merit, well, then you are looking at willful misconduct.
Well, but I thought that that's what the trial court was basing its decision on, was that there was a pattern. It wasn't like this was an isolated incident.
Well, I don't know how one decides what is or isn't a pattern.
That's what the trial court said.
Well, I understand what they said, but I'm not sure that that's correct. And they
So are
did-
you disputing that this was a pattern?
Certainly I'm disputing it. Mr. Fagan.
Was this an isolated incident by Mr. Fagan?
Well, I can't say, and let me tell you why. Mr. Fagan didn't appear at the hearing. There is no testimony from Mr. Fagan. The court had every opportunity, if they wanted to look at the willful misconduct of Mr. Fagan and say that the 11 supported a pattern, would have been to order him to appear and then go forward with an evidentiary hearing where we wouldn't be left to just guess why he took the actions that he took. Now, again, back to your point, I'm not saying this is how I would have handled it, but that's not the issue here. The issue is willful misconduct on the part of Mr. Fagan.
What goes into these affidavits? I mean, could he simply have said, I'd like some more time, or does he need to substantiate and say, well, I'm talking to expert so-and-so, and they're going to be out of town for a while? I mean, is this an involved process?
No, I think that asking for more time, which is fairly limited in terms of what the court's tolerance for more time would be to say, I have not yet been able to obtain an affidavit of merit for whatever reason, and I'm up against the statute of limitations or statute of repose.
I mean,
that isn't what happened.
If it's so simple, why?
Simplicity isn't answered by the statute that says if you don't abide by Rule 10, it's a failure otherwise than on the merits. It does.
But I think, like, the problem I have with how you presented that in the brief is suggesting that that is the only remedy at the court's disposal. Like, there's nothing that precludes the court from, as in this case, saying, well, I view this as sanctionable, and therefore I'm going to impose sanctions.
Well, viewing something as possibly sanctionable and finding evidence that supports it are two different things. The way that I see it compared to the way that you're questioning me, because I don't know how you see it one way or another at this point other than your question, is that the judge had every opportunity to develop the willfulness by simply ordering Mr. Fagan to appear. And
yeah, but I mean, that's not the argument you raise in your brief. I mean, you're not challenging this on a factual basis in the brief. As I understand it, the argument is simply that I have this, the safe harbor for refiling, and that essentially trumps Rule 10 and
which trumps
justifies
willfulness, I think, is the way Mr. Winter wrote it. Right. But your question went beyond that and said the judge found willfulness, and doesn't he have a right to do that and then enter an order that it was willful and then sanctionable? I don't think the record, as it was developed by the court in then ultimately getting to its ruling, is supporting the willfulness that you and I are currently talking about. And if you look at Judge Branch's decision, she specifically addresses that issue. Now, she went forward and denied it under the exact same set of facts. And the way I read it is, while she wasn't exactly very happy with Mr. Fagan, no one developed the issue of willfulness.
Is it about willfulness, or is it about frivolous conduct?
Well, I think that frivolous conduct has to have an element of willfulness or bad behavior.
But you just acknowledged the willfulness, which is he's filing this intentionally in derogation of the rules. Like, he's not complying with the affidavit of merit, and that's happened at least 2 occasions that we know, because Judge Branch and then this case.
Well, this is, to be honest, this is 3.
Okay,
cases.
well,
so it's
however many,
full.
yeah, right.
Yeah,
right.
and then I'm not going to try to hide from any
Right.
of this.
But so how is that, I mean, this isn't an accident.
I have no way.
But even if it's willful, is that sanctionable? Because can't it be trial strategy and
Well,
the other things? So
it-
is willful enough for it to be sanctionable?
Well, the issue on sanctions gets back to when you asked me, in essence, what would I do? And that really depends on the set of circumstances related to that case. Am I a day away from a statute running, and do I need to get it on and dismiss it so that I have the year?
It seems like there's a connection to a certain extent, although not necessarily, because there's other things that are sanctionable, but there can be a connection to malpractice. So the question, so would this be malpractice?
Would filing it without the AOM be malpractice?
Yes.
No.
And lacking the motion for the extension?
No, because the rule contemplates that doing that is a failure otherwise than on the merit that gives you a year to refile. So I don't think that it's malpractice if you don't have an AOM available to you and you have a client that appears on its face from your experience as an attorney doing these cases that this appears to be actionable malpractice. And this gets back to what Judge Bergeron is saying in my response to him, which is, in order to get to the sanctions issue, I really think, regardless of what I say in the brief, because the brief as written is based upon Judge Gehring's decision, and his decision is lacking in a factual basis to have gotten to where he ended up. And you can contrast that with Judge Branch, and you've got that dispute between judges at the common pleas level on the exact same set of facts, both of which had no testimony from Mr. Fagan, Judge Branch recognizing that fact, Judge Gehring not recognizing that fact.
Counsel, I noticed, at least in these three cases, I don't know about the other ones, but in these three, there was a motion to dismiss filed shortly after the complaints. And within a matter of mere days, sometimes even just one day, the complaints were voluntarily dismissed. So what we're talking about, I think, is just a complaint minus the affidavit pending for a day or two. How do we weigh that very limited period of time in looking at frivolity?
Well, if you're trying to obtain a judgment as Judge Gehring did, I think that cuts in favor of Mr. Fagan on the issue of the lack of the affidavit of merit, the fact the motion that dismiss was filed, and then a 41A voluntary dismissal was put on. It wasn't there stretching out the case as is cited.
But why should the defense there have had to brief the motion? Like, if you're saying this was all done and he was just trying to extend the shot clock, and so his intention was to file the dismissal, why did he wait until the defense had to go to the effort of filing a motion to dismiss?
The record is devoid of the reasons one way or another, which gets back to my argument that if the judge wanted to make these findings and didn't decide that, well, 11 is frivolous without any examination of those 11 cases, the statute of limitations, the statute of repose, or testimony, that's what we're left with. We're left with a record that is devoid by the judge and a knee-jerk reaction to seeing other matters that seem similar to this with no findings related to those other than this happened before. And I think that when you're looking at sanctions, my experience with the First District is you better fully have developed the factual basis in the underlying case to get this from a voluntary dismissal pursuant to Rule 10 and Rule 41 to a frivolous conduct sanctionable offense. And I don't think this record takes us there.
Well, but can you identify, I'm going back to the rule. The rule says you do one of two things. You file with the affidavit of merit, or you file the request for extension. Are you aware of any authority that would say there's this third option? This third option is you file the complaint, you don't file the affidavit of merit, you don't file the extension, and you just wait until someone calls you on it, and then you can.
The third option's right in the statute. Don't do one and two.
What statute?
I'm sorry, the rule, I misspoke. Rule 10. You don't do one and two, it's a failure otherwise than on the merits. So if you're looking for that extra year, if in fact that's what was developed in the lower court's record, which it wasn't one way or another, then the rule in terms of trial strategy and strategy to get the time not only to get the affidavit of merit, but to have filed within the statute of limitations. It may not save you on the statute of repose. We've all been there, and I argued it in the Supreme Court successfully as it relates to Dr. Durrani. I haven't evaluated this, even though the entire staff here thinks if I walk onto the 12th floor, it must be a Durrani matter. And they were surprised today that I wasn't here on that. But I just don't think the record supports where you're coming at me legitimately. I'm not saying your questions aren't legitimate, but I think that the rule speaks directly to this. If the rule wanted to say...
But then, like, your point is that we've got a year because we can just dismiss and refile, then why would anyone ever use the extension of time provision in Rule 10? I mean, doesn't that just subsume that within it?
Well, no, I think that there's expense to refiling. Number one, you got to pay a second filing fee, and with a jury demand, that is not inexpensive, especially when you have clients on limited budgets, unless you're an attorney that advances costs on behalf of the clients. So it's expensive, and if you just need a momentary pause because the doctor said, I can't write it up fast enough, but I can get it to you in a week or two, then you might use that extension.
But counsel, isn't it technically proper under the rule to file the complaint, ask for the extension, and then voluntarily dismiss if you can't come up with the affidavit? Isn't that what the rule contemplates for buying that 1 year?
No, the rule doesn't contemplate it. If you're asking me if that's reasonable to have done it, that may have been reasonable, but we don't have any of the facts in the record to decide whether the decision to put the continuance, the motion for more time attached to the complaint or not. We don't have that in the record.
Are you arguing that it's correct under the rule to file the complaint without either the affidavit or the motion for the extension?
Being incorrect and being frivolous are two different things. The rule supports the fact that you're not going to have committed malpractice if you don't attach it, because it's a failure otherwise than on the merits. And as long as you're not already outside the statute of limitations, or you're going to run into a statute of repose issue, well, then you've got a right to refile it. And so that's an issue related to all kinds of decisions that a lawyer has to make with the client in determining what has to be done. Now, this record doesn't have any of that. All we have is the dismissal. There's no refiling on any of these at this point in time, and I don't have a record that would indicate whether this was a second dismissal. Because I think if it's a second dismissal, then we look to what Judge Brandt says, and at that point, if you file twice without an affidavit of merit, well, that's not only frivolous, that's a bigger problem as well in terms of you and your client's relationship. And I have no issue with how she decided that, as angry as she appeared to be with Attorney Fagan for what she perceived to be underlying facts that were not developed to her satisfaction in making that ruling.
Unless there's any other questions from the panel. Thank you.
Thank you.
Good morning.
Good morning, Your Honors.
How are you doing?
Doing very well. It was a
Excellent.
pleasure to see my classmate appear here for the first time before the court.
Oh, nice.
Carlos, that was great. Your Honors, James Englert for, there are three appellees here. It's Bethesda, Mercy Health, and Dr. Malik. The reason that we filed this motion for sanctions here is that between November of 2021 and December of 2022, there were 14 cases filed by Mr. Fegan in which there were these exact circumstances as these three cases.
And while that's understandable, the court only allowed 3 of them to become part of the record. Isn't that right?
Well, they are part of the record. We identified, so of the 14, 3 of them are Lingo, Bias, and Cook, but the 11 others, we identified 7 in our brief, and then in the hearing, we identified another 4. But in all of these cases, there was the same pattern of no affidavit of merit, no motion for extension attached to the complaint, then a motion to dismiss by the defendant, and then followed by a quick dismissal of the complaint. And 2 of the cases had been filed. One was against Mercy before, one was against Bethesda. And, finally, this was enough, and we filed these in order to bring this pattern. It was a pattern to a stop.
Well, Rule 10 contemplates medical malpractice lawsuits being filed for a period of time without an affidavit of merit. And that was the exact circumstance that happened in all of these cases. What was missing was that motion for extension. But the cases just sat there without the affidavit. And if the rule contemplates that outcome, which it specifically does, how can that be frivolous?
It can be. It contemplates the outcome, and you have to do the motion for extension. You have a limited time to do the motion for extension, and to file the affidavit after that, and then so all
that's missing is just a motion for extension, something really simple and kind of administrative and ministerial. How can that be frivolous?
It can be frivolous because the purpose behind having the affidavit of merit is to deter the filing of frivolous med-mal cases. Okay?
I understand that. But the rule contemplates the cases not having one of those for a while.
It does, but even when the case is filed, the harm, if you can call it that, to the defendants, that starts immediately with the filing of the complaint. And that's there, and then you have to start investigating it. You have to get the records for the case. You have to interview the clients. You have to figure out whether there is actually some kind of claim here, and then you go ahead and you do the motion.
But all that could happen under the scenario that I asked your opponent about, where there is an extension filed and then ultimately a voluntary dismissal. And all of that would be proper under the rule. And you could still have the same consequences where you're investigating, gathering records, et cetera, preparing to defend the lawsuit, not realizing that this ultimate voluntary dismissal is coming. So how does the absence of a very ministerial motion that doesn't even go to the merits of the lawsuit constitute frivolous conduct? I'm missing that piece.
I think, Your Honor, it's just that there is no affidavit. The rule says that there has to be an affidavit of merit. Sometime there has to be an affidavit of merit. And why should it be that you can just ignore the rule and consider it optional to have this, and, I will get to it sometime, or maybe I won't, and then you have to leave it to the defendant to say, you need an affidavit of merit, okay? And to do it 14 times over the course of a year. So it should simply have been filed.
What if Mr. Fegan had responded, instead of filing voluntary dismissal notices, by filing the request for an extension? Would that have been proper?
it's, the motion for extension is supposed to be filed, it's supposed to be attached to the complaint. So I don't think it's proper to do it at that time. No.
Okay, so he couldn't cure it later.
Who knows what a trial court will do, but you know, the rule is structured to make that happen quickly. So, if it's all right,
And
I would.
going on that question,
Sure.
would it be under the trial court's discretion as to whether it would be granted or not?
Whether
even
the
though it
motion
would
for
be-
extension
Even
would
though
be
it would be
granted?
out of time pursuant to Rule 10?
I believe that it allows a certain amount of time and sort of contemplates that the motion will be granted. I didn't look at the rule just before this, but I think that's what the case is. Your Honors, if I could, I'd like to address the issue that was raised, that there is a lack of evidence and that the trial court didn't develop the finding of willfulness that's required under Rule 11. Of course, there's no subjective element that's required under the statute. That's just objective, you know, when it's a per se violation. And in this case, I mean, the statute sets out a very clear procedure, which Judge Gehring very carefully followed. There's supposed to be, there has to be a motion for sanctions, and the court has to set a hearing, has to give notice of the hearing, it has to have those.
Was there any opposition in their response to your motion to, did they dispute that this has happened the dozen times or whatever?
They did not, Your Honor. And in fact, I mean, they say that everything should be de novo before the court as a standard of review because they said that there's no, said that all the essential facts are you know, undisputed in this case. And I don't think that's quite correct because the subjective element was a factual finding that the court had to make. But as far as the not filing it in accordance with the rule, I think that was not raised as a defense. They said they did that, but they said, well, you know, there's no harm there. We're just allowed to file our Rule 41A dismissal.
Yeah, I mean, I took it that was their argument, at least in their appellate brief here, which is
Yes.
like some notion that the 41A dismissal transcends the Rule 10 requirement.
Right.
And so essentially, as I understood it, it was that, you know, even though the Rule 10 says shall, like we're not beholden to that.
Right. I think that they're treating it as optional, and I think that's just a mistake. And you know, there was evidence before the court, and Mr. Fegan was given notice of the hearing so that he could have come to the court. You know, the court didn't have to order him to do that. He chose not to appear there, and in effect, if you read the transcript, Mr. Mouse, who argued it for Mr. Fegan, is left to say, well, I practice a lot with Mr. Fegan, and we have all of these med-mal cases. We know what we are doing. He says, we could have filed an affidavit of merit. We file them all the time. And this was another element that Judge Gehring relied on in finding that, yes, there is knowledge. And he looked at not only those circumstances, but at the 11 other cases and found that there is a pattern on it, just as Judge Branch did in her opinion. And I think what's interesting about that opinion is that there is agreement on three major things. The first that's interesting is that she says, I mean, there's agreement between Judge Branch and Judge Gehring on three basic points. And Judge Branch said, the pattern of repeated knowing failure to follow Civil Rule 10D supports the finding of willful conduct that is subject to sanctions. So she found that, Judge Gehring found the same thing. And then Judge Branch said that she can't determine if the complaint is frivolous, and Judge Gehring said the same thing. He was very careful, you know, he's not finding anything on the merits. And then she also said that there's no sanction for a 41A dismissal. And again, Judge Gehring didn't sanction Mr. Fegan for dismissing the case. It was for the failure to file the affidavit of merit that happened earlier.
Well,
So-
counsel,
Yes, Your Honor.
I don't think it was for not filing the affidavit of merit. It was for not seeking an extension to file the affidavit of merit, right?
It was because they never got to the affidavit of merit, either by filing it or by asking for more time to file it. And that was the reason.
So it was a Rule 10
The Rule
issue,
10,
not
yes.
Rule 41.
Yes,
Okay.
yes. And what Judge Brance ultimately found where they differed is that she said that she can't find that there is no lack of merit in the complaint as things stand now. But what Judge Gehring did was go to the absence of the affidavit of merit or the motion for an extension, this very narrow issue, found that that had not been filed, and that warranted sanctions because there was subjective bad faith, subjective knowledge of willfulness, and violations of the rule. If the panel doesn't have any other questions? Okay.
Thank you.
Thank you for your consideration.
Counsel makes my point of the undeveloped record. His argument said that you've got to take into account that this complaint caused an investigation, it caused my client's damage, it caused all of these different things that go into developing the defense to this case. None of that is in the record. And so we're looking for frivolous conduct under the statute.
Well, we've got their fee records, right? I mean, that's what they got awarded.
Sure, you've got the attorney's time, but that is attorney's fees. That isn't the damage that they were talking about in terms of the defenses, the defendant's time, the defendant's anguish, the defendant's...
Yeah, I thought he was talking about it in terms of attorneys.
That's not how I heard. I'm sorry, I wrote the notes as he was talking.
Yeah.
So I'm not going to disagree with you. I just have the impression from what I wrote down. And so, again, when you're looking at this, it's twofold. Frivolous conduct under Rule 11, willful misconduct under the statute. I'm sorry, willful conduct under Rule 11, frivolous conduct under the statute. And the court in Master versus Chalco, which is cited in our brief, it's an 8th district court, talks about it being a factual determination. And I just don't believe that anyone's demonstrated any facts other than they spent some amount of attorney's fees, that I'm not going to contest the reasonableness of that for drafting a motion. I'm not saying that it then proximately was caused by Mr. Fagan's act. I'm just saying you draft a motion, and that's okay with me in terms of the amount you spend. So, again, I don't see the record supporting the judge's decision. I believe that the judge's decision should be reversed. Thank you.
Thank you both for your arguments this morning. We'll take the matter under consideration and issue a timely decision. Have a wonderful afternoon. Karen, give me a second. Let me gather all my stuff, okay? Hold on.